is no jurisdiction. They want to conduct discovery that's unlimited without specifying what jurisdictional elements that need to be explored. And the case law is pretty clear that's improper.
I guess since we're dealing with new issues and new motions, can I respond and ask Mr. Henry if he's finally done?
Yes, briefly, Mr. Tejas.
Well, I would ask for the same amount of time that the court's given Mr. Henry, because Mr. Henry is bringing up different stuff, and I thought this was just based off of what was already filed.
Well, yeah, I'm giving you time. I'm not going to cut you off, but again, as I mentioned when we started, I've read all the motions. And go ahead, Mr. Tejas. I'm not going to cut you off.
The problem we have is that we have an extremely vague order that was agreed to but written by the city. And I understand, and I actually agree with Mr. Henry regarding the enforcement should have been brought up in County Court 1 to enforce that agreed order. But where we disagree is that the city should have done the enforcement action through County Court at 1 prior to using their police powers to come in and basically raid the warehouse to enforce an extremely vague order. And that is what gives rise to the lawsuit that is now in the 49th. And so had they followed procedurally the way that they should have enforced their order in County Court 1 to get him off when there was no specified time frame at all on the order that they agreed to and that they wrote in County Court 1, we wouldn't be in this mess. I wouldn't have had to file lawsuits to stop them from using and enforcing this invalid order. And so we can go back and forth cyclical about, I should have filed it in County Court 1. The disagreement is, I think they should have filed it in County Court 1 prior to doing this. And what they've done is, ever since then, since the orders come in, has done things to frustrate and intervene and stop the evacuation or the movement out of the premises that they want us to do in the first place. And that falls into, and we deal with this every 2 weeks, we have to come in because we're trying to move things out of the premises, but the city still doesn't give us information on the FTZ application. They still don't give us access. They come in early to kick us out and frustrate our abilities to move everything out. And so the city complains of us not moving out, but their actions and what they do intentionally frustrates this purpose of us moving out. And so it turns into a cyclical issue that they're creating a problem, but then complaining about the problem. And so we're stuck with this, but the lawsuit is viable because it's an order. The remedies that they should have done to enforce that order were not done. They just came in and swooped in and tried to kick everybody out. Guns, I mean, this wasn't just, hey, get your stuff out. They brought in the police, they brought in customs officers, they came in as a police action to forcibly remove my client from the premises. That is a 1983 claim. And so the claim stands in and of itself. But the rest, I think it's contained in the motion, and we believe it's pretty straightforward. But yes, it should have been started in County Court 1, but the city should have started in County Court 1. When they didn't do that, they opened the door for this cause of action.
Well, let me just address the issue of where this should have been brought. And it's been raised before. And I've already decided that the district courts at least had concurrent jurisdiction over this matter. And again, but let me deal with the issues at hand. Mr. Tejas, I know what you're telling me in reference to some of the causes actions are different, but they really stem from the same occurrence. And again, the court had already made prior rulings regarding the finality of the decision made in County Court number 1. And one of the things I did, Mr. Tejas, just so you know that this was not a decision not made on a whim, was to go back and revisit the order that is the issue. But not only that, but look at the argument, the main argument, which is res judicata that the city is making in this case. And so I pulled it and copied and read through the counterclaim, which was filed by the plaintiff in this case, who was the defendant at that time, on December 4th, 2019, and read through it. And basically what I found is that it's the same causes of action that you have here now in the district court. And so without protracting this decision that I've come to is that the court is going to grant the city's motion for summary judgment and pleaded a jurisdiction on the grounds of res judicata. Yes, I understand it's different, but it's really out of the same occurrence. So any causes of action, if you look to the order, it's pretty clear that any claims which could have been brought were being dismissed in that order. So anyways, the court is making that ruling in reference to the summary judgment. I'm granting it. Now I want to address this issue about no timeline being addressed in that order. That is correct, but there is no limitation either on the city to come in and do exactly what they've been wanting to do, is to forcibly remove your client. Now, the court in this case, in order to avoid waste, has given Mr. Hoffman ample time to make arrangements to try. In fact, really the only issue that we should have left is the airplanes and the other, I don't know, 30 or 40% of the free trade zone merchandise, which I'm hoping more of that got removed somewhere else with a third party. But as far as the lawsuits in the district courts, those will be dismissed. I don't know if the city has filed a proposed order on that. If they have, I'll review it and sign it. So Mr. Diaz, having decided that, where are we on the move out?
We're where the court said we're at. It's the free trade stuff, the property pertaining to the airplanes, and that's it. There's some small stuff like pallets and stuff that helps facilitate the moving of the equipment that is needed to move the airplanes. We've received estimates from Barker Aerospace or whatever. It's another tenant of the city that they charged us, that they told us it would take them approximately 200 to 300 hours to disassemble and move those airplanes, each one. There is no other local place that can move the airplanes. But the problem we have is the city wants us to get the free trade zone stuff out. The city, the last time we were here, supposedly was going to give us an order, was supposed to give us a decision 2 weeks prior to our last hearing. We still haven't received anything in writing from the city giving us a thumbs up or a thumbs down regarding the application for the free trade zone. And so they were supposedly going to give it to us in 48 hours after last Friday's hearing. We don't have it. And so
I understand that, Mr. Diaz, and I know Mr. Henry doesn't have the final say so on whether or not your client's going to get that. But I think in the course of these hearings, and actually one of the requests that was made, which I responded to, was that the court has no authority to grant a free trade zone, and that I can't force the city to give you one. But they made it pretty clear that it probably wasn't going to happen. This is just the attorneys talking to each other in open court, but the sentiment from the city has been that they don't want to do business with Mr. Hoffman. I can't force them to do business with him. And if somehow they violated your rights by denying that, I mean, that's a separate matter. It may be a federal issue, but that's not really before me right now.
Well, regardless of whether it's a federal issue, Judge, the state courts are competent and adequate jurisdictional places, and so the actions are ongoing as far as what the city is doing. And I mean, I understand that the court doesn't have to force them, but the thing is, while we've been dealing with these negotiations, the court has an expectation on me to be forthright with the court and candor with and be honest with the court. Unfortunately, the city, even though they are technically public servants, and Mr. Henry, when he takes private cases representing the city, is expected to be a public servant because that's the role he's taking, as they have not been forthright. And even if they choose not to agree to give the FTZ zone, when they make representations, we're going to give you a decision in 48 hours. They should be expected to comply with it. I'm not asking the court to force them a thumbs up. They just got to give us a decision. And what they've done is intentionally frustrate the process. And where I take exception to it is the court holds certain things against us, but yet the city, whose obligation is to help the
No,
city,
hold on a second.
they don't do it.
The court did grant part of your request for temporary injunction, or else the city would have been in there a long time ago.
I understand.
So, yeah, no, and again, I mean, I'm trying to be fair without causing waste, but I do have to follow the law, and technically, there's really no reason, so if I choose to do so, to allow the city to go in tomorrow and take possession of everything, because there is an order of eviction. So to say that somehow the court has not been, at least sympathetic to what's going on here, we have, because we're past 6 months now. We're going on 6 months, or 7 months, where the city's had an order signed by, that's become final, where they have every right to go in there and do that. And this is the thing, Mr. Diaz.
And actually, court judge, I would just like to remind the court, like based on the ruling right now, the court has given them the opportunity to go in tomorrow and throw everything away. And the city
No, they're not doing that, because I started off this hearing by indicating that the decision of whether or not this should have been made by Judge Martinez in County Court Law 1 was already decided by me, and I determined that there was concurrent jurisdiction. And you've had ample opportunity to try to urge this to go back, and whether, I don't think that's actually been heard, but I probably would have denied it. But now that I've made the decision regarding the cases that are pending in district court, believe me, if you all are happy to file a joint motion to transfer the eviction process to Judge Martinez, I would gladly sign that. This has been a long case, Mr. Diaz. And look, Mr. Diaz, this is not a criticism. I realize you were not the attorney involved during the early process, and you've coming in secondhand. And again, you've done a good job for your client, but it's really hard to do that when the law is against you on at every turn almost. The court has tried to lessen the blow, regardless of what happened back in November, but I can only do so much, and it would be irresponsible of me to allow this lawsuit with your causes of action to go forward when it is clear that these causes of action could have been addressed or should have been addressed, again, at a time when you were not involved in County Court at Law number 1. But you brought this here to district court, so I have to make a decision on that, which I have. Mr. Diaz, and I don't know who is responsible for making that decision as to the FTC, but you should have gotten, and so have your client, a sense of where this was headed for the last few months. I mean, I made it very clear the last 2 times we met, and I was actually frustrated that more progress had not been made toward more eviction, and actually was upset that the price tag had not been placed on, or in a timeline on moving out the airplanes. I realize you have provided that to the court now and all that, but simply put, your client doesn't have that much time. And there's only so much I can do before the city would be within its right to request entrance into this. Anyways,
Your Honor, just for the court's information, we've had no objection to moving it for the, if it's going to be solely on the enforcement of the order, then we would ask that it would be dealt with the judge that entered the order, because at that point, he knows exactly what he meant when he said reasonable, when he wrote in the words reasonable, because unfortunately, I don't know what reasonable is when you're moving airplanes. I understand what it is if you have to move out of a house and you got to move your furniture, but there's a whole different, what's reasonable for vacating a residence is much different than
well,
vacating.
yeah, and Mr. Henry, basically, that argument makes sense, is that do we want to have Judge Martinez let you all know what he meant by reasonable? I think that sounds like a great idea now that I've made my decision on this case, and I have no problems with that. So is there going to be an objection to that, Mr. Henry? Mr. Diaz files a motion to transfer at least what's left, which is the eviction portion, to be transferred to the judge that actually made the decision on that.
Not exactly an objection, Your Honor. I guess it's the procedural element. The judge has the ability to enforce their own judgment, period, regardless of lawsuit or whatever. So if the district court case is dismissed, that judgment's still in effect. If Mr. Tejas wants to file a motion to enforce that with the judge, so we can find out what he meant by it, that's the proper process to go about doing it. I agree.
Yeah, but I want to make it very clear, until that happens, I'm not giving the city free rein to go in there and start evicting, because again, as I mentioned at the very beginning, at least for the purposes of what was going on in here, I mean, I guess I still have an order that's standing in reference to that. And any order regarding the summary judgment, I want this issue to be resolved, whether you're going to transfer it or not, so that, because there might be a procedural problem for me to continue on an injunction when basically the lawsuit is now dismissed.
Well,
So-
I mean, theoretically, I could always file a motion for a rehearing on the motion for summary judgment. So Mr. Henry doesn't necessarily have finality that he wants to just do it. So the question about the procedural.
Well, no, I mean, I could label the granting of the summary judgment and pleaded jurisdiction as partial, so that I can enforce my injunction. But again, if there's an issue with how the eviction is being handled by myself, by this court, then, and you want to have the judge that actually signed the order be the final word on how that's going to be enforced, I think that makes sense.
There's no objection from us, Your Honor, to transferring it to Judge Martinez.
Okay, so Mr. Diaz, can you include, or can you all work, or Mr. Henry's, to add in that the final issue, and that way that 49th case can be closed out in its entirety? Jen? Mr. Henry, unrelated to this case, you're going to get a call from Joanne Hernandez. I can't remember what it is. Nothing, you're not in trouble.
Okay.
They need to ask you something on another case you've had in front of me. Again,
Okay, Your Honor.
it's strictly procedural. Nothing's being undone. I mean, it's just, I had a question, and
Is that the Valero matter, Your Honor?
it might be something else, but it's
Okay.
Your Honor, is that it on this matter?
Yes, that concludes everything else on this. Are you available in the next 10 minutes, Mr. Henry?
I am, Your Honor. Are you, just to confirm, we still have the sanctions out there, but if you're granting all of our relief, and it's going to be transferred.
Oh, I forgot well, I read through that and the sanctions are being denied.
Your Honor, we had filed the responses that were required for the sanctions anyway, just before the.
Well, I'm denying, yeah, I saw that. I mean, I understand. And again, well, the case is done, so let's move
Yes,
on.
Your Honor.
Thank you, everyone. Everyone's, I guess, excused.
Thank you, Judge.
Thank you, Your Honor.
All right.
I will, do you just want me to hang out here or wait for the, like an audio phone call?
Well, hold on a second. Let me get everyone out and see what Joanne wanted. Hold on. Thank you, Blanca. We're done here.
Can I be excused, Your Honor?
Have a good weekend, Judge.
Likewise. Let me turn off all the recordings.